I knew something was wrong the moment I saw the crisp white envelope tucked into my mailbox with the HOA logo embossed on the front. My golden retriever, Max, wagged his tail beside me as I pulled it out, completely oblivious to the fact that this letter would turn our peaceful life in Riverside Meadows, California, into a legal battleground. The letter was dated March 15, 2026, and signed by Patricia Whitmore, the HOA president. I stood there on my driveway, reading the words that made my blood pressure spike with each sentence. Effective immediately, the HOA was implementing new pet regulations. Dogs over 50 pounds were no longer permitted in the community. Residents had 30 days to rehome their animals or face daily fines of $200 until compliance was achieved. Max weighed 78 pounds. I had owned him for 4 years, and we had lived in this house for 3 of those years. When I purchased my home in June 2023, there were no restrictions on pet size in the covenants, conditions, and restrictions document I had signed. I had specifically checked because Max was already part of my family, and I refused to live anywhere he was not welcome. I walked back inside, my hands shaking with anger. My neighbor, Tom Chen, was outside watering his lawn, and I called over to him. "Did you get one of these?" I held up the letter. Tom nodded grimly. "Yeah, we have a German Shepherd, 85 pounds. My kids are devastated." "This is insane," I said. "They cannot just change the rules like this and expect us to get rid of our dogs." "Patricia came by yesterday, measuring our fence," Tom said. "She had this smug look on her face the whole time. Said the new rules were approved by the board last week." I went inside and immediately pulled out my closing documents. I spent the next 2 hours combing through every page of the CC and Articus I had signed when I bought the house. There was nothing, absolutely nothing, about dog weight limits. The pet policy stated that residents could own up to 2 domestic pets, and they had to be leashed in common areas. That was it. The next morning, I called the HOA office. A woman named Jennifer answered, her voice professionally cheerful. "I received a letter about new pet regulations," I said, trying to keep my voice level. "I need to understand how this was implemented." "The board voted on it at the March meeting," Jennifer said. "The new rules are in effect as of the date on your letter." "But I purchased my home with a dog that is now suddenly illegal. How is that fair?" "The board has the authority to amend community rules as needed," she said, her tone becoming less friendly. "If you have concerns, you can attend the next board meeting on April 2nd. "I will definitely be there," I said and hung up. I immediately started researching HOA law in California. What I found gave me hope. HOAs could not simply change rules retroactively without proper legal foundation. They definitely could not force existing homeowners to get rid of pets they already owned based on new rules that did not exist when those pets were acquired. I decided to call an attorney. I found a firm in Sacramento that specialized in HOA disputes, led by a lawyer named David Fitzgerald. His receptionist scheduled me for a consultation the following afternoon. David Fitzgerald was in his mid-50s, with graying hair and sharp eyes that suggested he had seen every HOA trick in the book. His office was lined with legal books, and he had a wall of framed certificates and commendations. "Tell me everything," he said after we shook hands. I explained the situation, showing him my original CC and Articus and the letter from Patricia Whitmore. He read through both documents carefully, occasionally making notes on a legal pad. "This is textbook illegal," he finally said. "They are attempting to apply new restrictions retroactively. California law is very clear on this. CC and Articus can be amended, but amendments cannot be applied retroactively to deprive homeowners of rights they had when they purchased their property. So I can keep Max. I felt relief flooding through me. Absolutely. But there is more to this. They are threatening substantial fines, which could constitute harassment, and if they did not follow proper procedures for amending the CC and Artic S, the entire change might be void anyway. What are the proper procedures? David leaned back in his chair. First, they need a valid vote of the board, properly noticed. Second, for significant changes to CC and Artic S, they typically need approval from a certain percentage of homeowners, not just the board. Third, they have to file the amendments with the county. Let me make some calls and see what they actually filed. He charged me a $2,000 retainer, which I paid immediately. This was worth it. Max was not just a pet. He was family. Over the next week, David did his research. He discovered that Patricia Whitmore and her 3-person board had indeed voted to change the pet rules, but they had not sought homeowner approval. They had not filed anything with Riverside County. They had simply decided among themselves and sent out letters. This is even better than I thought, David told me over the phone. The amendment is completely void. They followed none of the required procedures. I am drafting a response that will make it very clear they need to rescind this immediately. What if they do not? I asked. Then we file suit, and they will lose. Badly. And the HOA will have to pay your attorney fees on top of their own legal costs. Most HOA boards back down when they realize how much this will cost the community. But David did not know Patricia Whitmore. The April 2nd board meeting was held in the community clubhouse, a bland beige building with folding chairs and fluorescent lights. When I arrived at 7 in the evening, the parking lot was packed. I was not the only angry pet owner. Patricia Whitmore sat at a folding table at the front of the room with 3 other board members. A thin man named Gregory Sanders, a nervous-looking woman named Diane Murphy, and a younger guy named Keith Brennan who kept checking his phone. Patricia was exactly what I expected. She was in her late 50s, with short blonde hair styled in that aggressive Karen cut that seemed to be regulation for power-hungry HOA presidents. She wore a pantsuit and had reading glasses on a chain around her neck. Tom Chen was there with his wife and 2 kids. I recognized at least 15 other residents, many of whom I knew had larger dogs. Patricia called the meeting to order by banging a gavel like she was a judge. Before we begin with community concerns, I want to address the new pet regulations, she said. Some residents have expressed confusion about the policy. Let me be clear. The board has the authority to implement rules that maintain property values and community standards. Large dogs present safety and noise concerns. The new regulations stand. I raised my hand. I am Ethan Foster, 2847 Willow Drive. I have reviewed the CC and Artic S, and there is nothing in there that authorizes this change. You cannot retroactively ban pets that were legally owned when residents purchased their homes. Patricia gave me a condescending smile. Mr. Foster, the board has broad authority to create and enforce community rules. This was a properly voted decision. Did you get homeowner approval for this CC and R amendment? I asked. We do not need homeowner approval for rule changes, Patricia said. That is why residents elect a board. Actually, you do need approval for CC and R amendments, I said. And you need to file them with the county. Did you do either of those things? Patricia's smile tightened. We followed all necessary procedures. If you have further questions, you can submit them in writing to the HOA office. I have already submitted something in writing, I said. Through my attorney, you should be receiving it tomorrow. That got her attention. The room went silent. Patricia's face flushed slightly. Are you threatening legal action against your own community? She asked. I am protecting my property rights, I said calmly. You are the one threatening to fine residents $200 a day for owning pets that were completely legal when they moved here. Tom Chen stood up. I have 3 kids who love our dog. You think I am just going to give her away because you decided you do not like big dogs? This is our home, we paid for it. Other residents started speaking up, voices overlapping. Patricia banged her gavel repeatedly. Order, we will have order, she shouted. The rule stands. If you do not comply, you will be fined. This meeting is adjourned. She stood up and walked out, the other board members scrambling to follow her. The rest of us sat there, stunned and furious. Anyone who wants to fight this, I am working with an attorney, I said to the room. His name is David Fitzgerald. I will send around his information. By the end of the night, 12 families had signed up to join the legal action. The next week, David sent a formal cease and desist letter to the HOA board, copied to all members. It laid out in excruciating legal detail exactly why their pet rule change was void. It cited California Civil Code sections 4350 and 4360, which governed how CC and Articus could be amended. It pointed out that the board had failed to obtain the required homeowner vote, failed to file documents with the county, and was attempting to apply restrictions retroactively in violation of basic contract law principles. The letter demanded that the HOA immediately rescind the pet rule change and confirm in writing that no fines would be assessed against any homeowner for pets that were legally owned prior to March 15, 2026. Patricia's response was delivered 3 days later, not through an attorney but in a letter on HOA stationery. She claimed the board had acted within its authority, the rules were valid, and fines would begin on April 15 as scheduled. She is doubling down, David said when I showed him the letter. Okay, time to file suit. On April 10, David filed a lawsuit in Riverside County Superior Court. The case was Ethan Foster et al. v. Riverside Meadows Homeowners Association. There were now 18 plaintiff households. The complaint asked the court to void the pet rule change, enjoin the HOA from assessing fines, and award attorney fees and costs. When the HOA was served with the lawsuit, Patricia went into overdrive. She sent out a community-wide email claiming that a small group of entitled pet owners was costing the community thousands of dollars in legal fees to defend a reasonable safety measure. She suggested that all homeowners might face a special assessment to cover the legal costs. That backfired spectacularly. Homeowners who did not even have pets started calling the HOA office, furious that Patricia was racking up legal bills instead of just backing down. An online petition started circulating to recall the board. Meanwhile, April 15 came and went. Patricia sent out fine notices to everyone with large dogs. $200 per day, starting to accumulate. My first fine notice said I owed $600 for 3 days of non-compliance. David immediately filed an emergency motion for a temporary restraining order to stop the fines. The hearing was set for April 22. The courtroom was smaller than I expected, with wood paneling and harsh overhead lights. Judge Martha Hendricks presided, a stern woman in her 60s who had a reputation for not suffering fools. David argued that the fines were causing immediate irreparable harm, and that we were likely to succeed on the merits because the pet rule change was procedurally void. The HOA had finally hired an attorney, a guy named Robert Pace who specialized in representing HOAs. He was in his 40s, wearing an expensive suit, and he argued that the board had broad discretion to adopt rules and that residents who did not like the rules could vote out the board. Judge Hendricks listened to both sides, then asked Robert a pointed question. "Counselor, did your client obtain homeowner approval before amending the CC and Articles regarding pets?" Robert hesitated. "Your Honor, the board believes this was a rule adoption, not a CC and R amendment, which does not require homeowner approval." "The original CC and Articles allow pets," Judge Hendricks said. "And now you are saying certain pets are not allowed. How is that not an amendment?" "It is a clarification and implementation of standards, Your Honor." "It sounds like an amendment to me. Did you file anything with the county recorder?" "No, Your Honor, because again, we believe this was a rule adoption under the board's general authority." Judge Hendricks looked unimpressed. "I am granting the temporary restraining order. No fines will be assessed pending resolution of this case. I am also ordering the parties to mediation. We are not going to waste judicial resources on something this straightforward." We walked out of the courthouse, and I felt like I could breathe for the first time in weeks. Max was safe, at least for now. The mediation was scheduled for May 15 at a neutral location in Riverside. The mediator was a retired judge named Harold Simmons, who had dealt with hundreds of HOA disputes. Patricia showed up with Robert Pace and the other 3 board members. Our side had David, me, and representatives from 3 other plaintiff families, including Tom Chen. Harold Simmons laid out the situation bluntly. "The HOA's legal position is weak. You did not follow proper amendment procedures. You are applying restrictions retroactively, and you are exposing the community to significant legal liability. The smart move is to rescind the pet rule change and settle this case." Patricia crossed her arms. "Those dogs are a nuisance and a safety hazard. We have had complaints." "How many complaints?" Harold asked. Patricia looked at Gregory Sanders, who shuffled through some papers. "We have received 4 complaints about dogs in the past year." "4 complaints out of how many homes?" Harold asked. 230 homes, Robert Pace admitted. "And how many of those complaints involved dogs over 50 pounds specifically?" Gregory looked uncomfortable. "1." I nearly laughed. 1 complaint, and Patricia was trying to ban all large dogs. "This is absurd," Tom Chen said. "You are trying to force families to give up their pets because 1 person complained." "It is about maintaining standards," Patricia said coldly. "When I bought in this community 15 years ago, it was well kept and family-friendly. Now we have dogs barking at all hours, people not cleaning up after their pets, and property values are suffering." "Do you have any evidence that property values are declining?" David asked. "It is common sense," Patricia said. "Common sense is not a legal standard," Harold Simmons said. "Look, I am going to be direct. If this goes to trial, you are going to lose. The judge already indicated skepticism about your legal position. When you lose, the HOA will have to pay not only its own legal fees, but also the plaintiff's fees. We are talking about tens of thousands of dollars that will come out of the community's reserves or through a special assessment on every homeowner." "We have insurance," Patricia said. "HOA insurance policies typically do not cover legal fees for cases where the board acted outside its authority," Robert Pace said quietly. "And even if they did, our premiums would skyrocket." Patricia went silent, her jaw clenched. We took a break. David pulled me aside. "She is not going to back down easily. This is personal for her now. She cannot admit she was wrong." When we reconvened, Harold Simmons proposed a settlement. The HOA would rescind the pet weight limit for any pets owned as of March 15, 2026. Going forward, new residents would be subject to a 50-pound limit, but that would be implemented through a proper CC and R amendment process with homeowner approval. All fines would be waived, and each side would bear its own attorney fees. David looked at me and the other plaintiffs. We had a quick huddle. I do not like that they get to keep the rule for new residents, Tom said, but they have to go through proper procedures, I said, which means getting a majority of homeowners to approve it. Good luck with that. We agreed to the settlement terms. Patricia and the board had to caucus with Robert Pace for nearly an hour. When they came back, Patricia looked like she had been forced to swallow poison. "We agree to the settlement," she said stiffly. "Harold Simmons drafted the agreement, and we all signed it." The lawsuit would be dismissed with prejudice, meaning it could not be refiled. I thought that was the end of it. I was wrong. 2 weeks later, on May 28, I got another letter from the HOA. This one informed me that my property had been inspected and I was in violation of community standards. My fence needed repainting, my lawn had weeds, and my mailbox post was damaged. I had 14 days to correct the violations or face fines of $100 per day per violation. I walked outside and looked at my property. My fence was fine, painted just 6 months ago. My lawn had maybe 3 dandelions, no worse than any other lawn on the block, and my mailbox post had a tiny scratch from where I had bumped it with my car, barely visible. Tom Chen called me that evening. "Did you get a violation notice?" "Yeah, completely bogus. You too." Me and 5 other families, all of us were plaintiffs in the lawsuit. She is retaliating. I called David Fitzgerald immediately. "We have a new problem." David was not surprised. HOA board members are vindictive sometimes. Document everything. Take photos of your property and your neighbors' properties. If there are violations on your property that do not exist on similar properties owned by non-plaintiffs, that is evidence of selective enforcement and retaliation. I spent the next day photographing every fence, lawn, and mailbox in Riverside Meadows. It was not hard to find properties in worse shape than mine that had not received violation notices. In fact, 2 board members had visibly damaged fences and overgrown landscaping. David sent another letter to the HOA, this one warning them that retaliatory enforcement was illegal under California Civil Code Section 5850. He included photos showing that the alleged violations were either non-existent or were being selectively enforced only against lawsuit plaintiffs. Patricia's response was to double down again. She sent me a second violation notice adding more alleged infractions, including that my trash cans were visible from the street on a non-trash day, which was apparently a violation I had never heard of before. "She is out of control," David said. "We need to go back to court." On June 5, David filed a motion for sanctions against the HOA for violating the settlement agreement and engaging in retaliatory enforcement. He also filed a separate lawsuit for harassment and requested punitive damages. This time, Robert Pace called David directly. "My client is making my job very difficult. I have advised her repeatedly to stop this behavior." "Then withdraw from representing them," David said. "I am considering it." 3 days later, Robert Pace did exactly that. He filed a motion to withdraw as counsel, citing irreconcilable differences with the client. The judge granted it. The HOA board now had to find new representation, but most HOA attorneys in the area had heard about the case and did not want to touch it. Patricia ended up hiring a general practice attorney named Mark Sullivan, who did not have much HOA experience but was willing to take the case. The hearing on David's sanctions motion was set for June 20. The night before the hearing, something unexpected happened. I got a call from Deanne Murphy, one of the board members. "Mr. Foster, I need to talk to you," she said, her voice shaking. Can we meet somewhere private? We met at a coffee shop in downtown Riverside. Deanne looked exhausted. She ordered a coffee and sat down across from me. I am resigning from the board, she said. I cannot do this anymore. Patricia has lost her mind. This whole thing started because she personally does not like dogs. She got bit by a dog when she was a kid, and she has had this vendetta ever since. She is costing the community a fortune in legal fees over a childhood fear of dogs, I said. It is worse than that, Deanne said. She has been using HOA funds inappropriately. We are supposed to approve all expenditures over $500, but she has been writing checks without board approval. I think she is paying for personal expenses and disguising them as HOA costs. That is embezzlement, I said. I know. I told Gregory and Keith, but they are too scared of her to do anything. I am giving you this information because I think you should tell your attorney, and maybe the police. Do you have evidence? Deanne pulled out a folder. I made copies of bank statements and canceled checks before I decided to resign. I probably should not be giving these to you, but I cannot be part of this anymore. I took the folder and called David immediately. He told me to bring the documents to his office first thing in the morning. David reviewed the bank statements carefully. Over the past 18 months, Patricia had written checks to herself totaling nearly $40,000. The memo lines said things like reimbursement for community expenses and consulting fees, but there were no receipts or documentation. This is criminal, David said. You need to file a police report. I went to the Riverside Police Department and spoke to a detective named Sarah Morrison. She was in her 30s, sharp and no nonsense. I showed her the bank statements and explained the situation. HOA embezzlement cases are tricky, she said. Technically, it is a civil matter unless we can prove criminal intent, but $40,000 is significant. Let me look into this. Detective Morrison started investigating. She subpoenaed the HOA's bank records and interviewed other board members. Gregory Sanders and Keith Brennan both confirmed that Patricia had been writing checks without authorization. On June 19, the day before our court hearing, Detective Morrison arrested Patricia Whitmore at her home on charges of felony embezzlement and theft. The arrest made the local news. Residents of Riverside Meadows were shocked. The June 20 hearing went forward, but without Patricia. Mark Sullivan asked for a continuance, but Judge Hendricks denied it. Your client was engaged in systematic retaliation against homeowners who exercised their legal rights, Judge Hendricks said. I am granting the motion for sanctions. The HOA will pay $50,000 to the plaintiffs and cover all attorney fees. Additionally, I am ordering the board to rescind all violation notices issued against the plaintiffs and barring the HOA from selective enforcement. Gregory Sanders, now the acting HOA president, stood up. Your Honor, the board would like to apologize to Mr. Foster and the other residents. We were wrong. Patricia Whitmore was acting beyond her authority and we failed to stop her. See that it does not happen again, Judge Hendricks said. After the hearing, Gregory approached me. I know this has been a nightmare. The remaining board members are planning to resign. We are going to call for a special election so residents can choose new leadership. In the meantime, we are suspending all enforcement actions except for serious safety violations. That is a good start, I said. Patricia Whitmore's criminal case moved forward. In August, she pleaded guilty to embezzlement and was sentenced to 2 years in county jail and ordered to pay full restitution to the HOA. The judge noted that she had abused a position of trust and caused significant harm to her community. The special election was held in September. A new board was elected, including Tom Chen as president. One of their first actions was to formally rescind the pet weight limit rule. They also implemented new financial controls to prevent future embezzlement. In October, the new board sent out a community-wide letter apologizing for the previous board's actions and outlining new policies for transparency and accountability. They established a website where residents could see financial statements, meeting minutes, and proposed rule changes. They created a process for residents to appeal violation notices before fines were assessed. Life in Riverside Meadows slowly returned to normal. Max and I went on our daily walks without worrying about violation notices. Tom Chen's kids played in their yard with their German Shepherd. The community actually felt like a community again. I ran into Gregory Sanders at the grocery store in November. He looked relieved, like a weight had been lifted. "I should have stood up to Patricia earlier," he said. "I knew what she was doing was wrong, but I did not want the confrontation." "I am sorry you had to go through all that. Just do not let it happen again," I said. "HOAs are supposed to serve residents, not control them." "Agreed. Tom is doing a good job as president. He actually listens to people." The final chapter came in December. The HOA sent out year-end financial statements showing that, despite the legal costs and Patricia's embezzlement, the community was financially stable. The new board had renegotiated several vendor contracts and found significant savings. They were even planning to use reserve funds to upgrade the community park. David Fitzgerald sent me a final bill showing that the HOA had paid all my attorney fees as ordered by the court, totaling $38,000. I did not owe him anything. "This was one of the more satisfying cases I have handled," David told me over the phone. "You stood up for your rights, and you were completely in the right. Too many people just give in to HOA bullying." "I had a good attorney," I said, "and I had a good client who was willing to fight." On Christmas Eve, I was decorating my house when Tom Chen came over with a bottle of wine. "Thought you might like this," he said. "It has been quite a year." We sat on my porch, watching Max and Tom's German Shepherd play in my yard. The Christmas lights were twinkling on houses up and down the street. "You know what the crazy thing is?" Tom said. "Patricia actually did us a favor. Before all this, nobody paid attention to the HOA. We just paid our dues and ignored the whole thing. Now we have residents showing up to meetings, asking questions, staying engaged. We are actually building a real community." "That is a good way to look at it," I said. "My kids wanted me to thank you, by the way. They said you saved our dog." "I just did not want to lose mine," I said. "But I am glad it worked out for everyone." We sat there in comfortable silence for a while, two neighbors who had been through something difficult together and came out better for it. The lesson I learned was simple but powerful. HOAs have authority, but that authority is not unlimited. They have to follow the law just like everyone else. When they do not, you have the right to fight back. It might be expensive, it might be stressful, but sometimes you have to stand up for what is yours. Max nudged my hand with his nose, wanting attention. I scratched behind his ears, grateful that he was still here, still part of my life. Patricia Whitmore had tried to take that away based on nothing more than her own personal hang-ups and a desire for control. But the law had other ideas. Property rights matter. Contracts matter. Due process matters. You cannot just change the rules in the middle of the game because you feel like it, especially when those rules affect people's homes and families. The new year came, and with it, a sense of renewal in Riverside Meadows. The community had been through a rough patch, but we had come through it stronger and more united. The new board was doing good work, and residents felt heard and respected. I still see the families who were part of the lawsuit around the neighborhood. We have a bond now, a shared experience of standing up against injustice and winning. Our dogs play together at the community park, and nobody worries about violation notices or fines. In February, the community held its annual meeting. The attendance was 3 times higher than it had been in previous years. Tom Chen presented the budget, explained upcoming projects, and asked for resident input. It was democratic, transparent, and respectful. When someone raised a question about whether we should have any pet restrictions at all, Tom handled it perfectly. "If anyone wants to propose a rule change, we have a process for that," he said. "You can submit a proposal, we will discuss it at a board meeting, and if it requires a CC&R amendment, we will put it to a community vote. That is how it should work. No more unilateral decisions from the board." The room applauded. After the meeting, a new resident came up to me. She had just moved in and had a young Labrador retriever. "I heard about what happened last year," she said. "Thank you for fighting that. It is one of the reasons I felt comfortable buying here. I knew the community had good people who would stand up for what is right." That meant more to me than any legal victory. We had not just won a lawsuit. We had changed the culture of our community. As winter turned to spring, I reflected on everything that had happened. It had started with one unreasonable letter from one unreasonable person. It had escalated into a legal battle, uncovered embezzlement, resulted in a criminal conviction, and ultimately transformed an entire community. The thing about HOAs is that they are run by volunteers. Sometimes those volunteers are well-meaning people who want to help their community. Sometimes they are petty tyrants who abuse whatever small amount of power they are given. The key is having systems in place to prevent abuse and hold people accountable when they overstep. Riverside Meadows now had those systems. We had transparency in finances. We had clear procedures for rule changes. We had an engaged resident population that paid attention and asked questions. And we had leaders who understood that their job was to serve, not to rule. Patricia Whitmore was released from jail in early 2028 after serving 16 months of her 2-year sentence. I heard through the grapevine that she moved out of state, presumably to start over somewhere her reputation had not preceded her. I felt a small amount of pity for her. She had let her fear and need for control destroy her life and hurt a lot of people in the process. But mostly, I just felt grateful. Grateful for Max, who was getting older but still loved his daily walks. Grateful for my home in a community that had learned hard lessons about governance and accountability. Grateful for neighbors like Tom Chen, who stepped up when leadership was needed. And grateful for attorneys like David Fitzgerald who knew the law and were willing to fight for what was right. The story of the retroactive pet rule change became something of a legend in Riverside Meadows. New residents heard about it and understood that this was a community where people stood up for their rights. The HOA board members who came after Tom Chen all knew the story and understood the importance of following proper procedures. In a way, Patricia's overreach had vaccinated the community against future abuse. Everyone now knew what could happen when an HOA board acted without accountability. Everyone understood their rights and responsibilities, and everyone was committed to making sure it never happened again. Max passed away peacefully in his sleep in the summer of 2029. He was 11 years old and had lived a good life. I buried him in a pet cemetery in Riverside with a headstone that read, "Max, a good boy who was worth fighting for." Several neighbors attended the small memorial service I held. Tom Chen gave a short speech about how Max had inadvertently become the catalyst for positive change in our community. It was touching and true. I adopted another rescue dog a few months later, a mixed breed named Charlie who weighed 65 pounds. There were no complaints, no violation notices, no threats, just neighbors stopping by to meet the new addition and welcome him to the neighborhood. The Riverside Meadows HOA continued to function smoothly. Annual meetings were well attended and productive. The budget was always balanced and transparent. Rule changes went through proper procedures with resident input. It was everything an HOA should be. A practical organization that maintained common areas and enforced reasonable standards without overstepping into residents' personal lives. Looking back on the whole experience, I realized that the fight had never really been about pets at all. It had been about power, control, and whether residents had any real rights in a community governed by an HOA. Patricia Whitmore had believed that the board's authority was absolute, that residents had to comply with whatever rules she decided to impose, regardless of the law or fairness. She had been proven wrong in the most definitive way possible. The courts had sided with the residents. The law had been clear, and the community had rejected her vision of authoritarian control in favor of democratic governance and respect for property rights. The legal principles that won the case were not complicated. You cannot change contract terms retroactively. You cannot apply new restrictions to deprive people of rights they had when they entered into an agreement. You have to follow the procedures set out in your governing documents. And you cannot retaliate against people for exercising their legal rights. These principles apply not just to HOAs, but to any situation where one party has authority over another. Power has to be exercised within legal and ethical bounds. When it is not, people have the right and the responsibility to push back. I stayed in touch with David Fitzgerald over the years. He continued to represent homeowners in disputes with overreaching HOAs. He told me that the Riverside Meadows case had become useful precedent in his practice. When he sent demand letters to HOAs threatening to implement retroactive rule changes, he would cite our case as an example of what happened when boards ignored the law. "You helped a lot of people beyond your own community," he told me. Every time an HOA backs down because they do not want to end up like Riverside Meadows, that is a homeowner who did not have to go through what you went through. That felt good. The fight had been worth it, not just for me and Max, but for people I would never meet who benefited from the precedent we had set. As I sit here now, years after that first threatening letter appeared in my mailbox, I can say with certainty that I made the right choice. I could have given up Max, avoided the conflict, and gone on with my life. Many people would have done exactly that. It would have been easier in the short term, but it would have been wrong. It would have meant letting fear and intimidation win. It would have meant accepting that HOA boards could do whatever they wanted without consequence, and it would have meant losing a member of my family for no good reason. Instead, I fought. I spent money I would rather have saved. I spent time I would rather have spent doing other things. I dealt with stress and anger and frustration, but in the end I won. Max stayed, the community improved, and justice was served. That is what I want people to take away from this story. When you are in the right, when the law is on your side, when something truly matters to you, it is worth fighting for. Yes, it is hard. Yes, it is expensive. Yes, it is stressful. But giving in to injustice is worse. HOAs serve a legitimate purpose. They maintain common areas, enforce reasonable standards, and preserve property values. But they are not above the law. They do not have unlimited authority. And when they abuse their power, residents have both the right and the means to fight back. If you find yourself in a similar situation, here is my advice. First, read your CC and Articus and governing documents carefully. Know your rights. Second, document everything. Keep copies of all letters, take photos, save emails. Third, do not try to fight an HOA without an attorney who specializes in this area. The law is complicated, and you need someone who knows it inside and out. Fourth, do not be afraid to stand up for yourself. Bullies back down when confronted with strength and determination. And finally, remember that you are not just fighting for yourself. You are fighting for every resident in your community who might face similar abuse in the future. You are setting a precedent. You are drawing a line. You are saying that power must be exercised responsibly and within legal bounds. The Riverside Meadows HOA tried to change the rules retroactively and force residents to give up their pets. My attorney showed them why that was void. The courts agreed. The law prevailed. And a community learned an important lesson about accountability, transparency, and respect for property rights. It was not an easy fight, but it was a necessary one. And I would do it again in a heartbeat.